The delegation is now ready to respond to all of our questions at this resumed 2955th meeting of the committee. So without more ado, I pass the floor to Madam Chang, the head of the delegation, to organize the responses as she deems appropriate. You have the floor, ma'am.
Thank you, Chairman. We will try to answer the questions the best we can. Following the sequence of this hearing, we would like to cover first the supplementary questions made at the beginning of the session. First of all, I would like to invite our Solicitor General, Mr. Frank Poon, to talk about a few legal issues, including interpretation of basic law, application of national law to Hong Kong or vice versa, and the definition of treason and sedition in the laws of Hong Kong. Mr. Poon.
Thank you, Mr. Chairman. I would take the floor to clarify some of the legal issue raised by distinguished members of the committee. The first question that I would like to address is the interpretation of the basic law. There were questions about whether the interpretation of the basic law could be on a provision in Chapter 3 of the Basic Law of Hong Kong, which guarantees the basic rights and freedom of the citizens of Hong Kong. The answer to that question actually lies in a Court of Final Appeal court case in which the Court of Final Appeal, in the case of Lau Kong Yung, has confirmed that the power of the MPC Standing Committee to interpret the basic law is a general one, and that power is expressed in the basic law in unqualified terms. So the Court of Final Appeal in Hong Kong has acknowledged that the MPCSC could theoretically interpret each and every provision of the basic law if it finds it necessary. But in the previous occasion, when we refer to the 4 occasions in the past in which the basic law was interpreted by the MPCSC, there was only one occasion when the interpretation relates to Chapter 3, and that was on Article 24 of the Basic Law of Hong Kong relating to the right of abode of certain mainland-born residents. And except for that one, there has been no interpretation relating to Chapter 3 of the Basic Law. I think I would like to elaborate more on that because that might sound alarming. But the first point that I would want to state very clearly here is that the Hong Kong SAR government takes the view that unless in very exceptional situation, we will not request any interpretation of the basic law from the MPC Standing Committee. And we have exercised that self-restraint, and we have seen the Central People's Government exercising that self-restraint. So in the past 15 years, there have only been 3 occasions when there was an interpretation of the basic law on the initiative of the Hong Kong SAR government or the Central People's Government. The other occasion was actually requested by the court using its power under Article 158 of the Basic Law. And the other factual information that I can give here is that there has been no interpretation by the MPCSC on Article 39 of the Basic Law, which applies the which applied the ICCPR to Hong Kong. Now, the question, I think, should also have regard, or in discussing this question, we should also have regard to the power of the MPs of the MPCSC to interpret the Basic Law. And that question is whether it might adversely affect the rights guarantee under the ICCPR as applied to Hong Kong by Article 39 of the Basic Law. Now, the power, as I said before, to interpret the Basic Law is a general one. So as a matter of principle, an interpretation by the MPCSC is issued in order to clarify the legislative intent of any provision of the Basic Law if it deems fit. But I think we have to bear in mind that the MPCSC, the Standing Committee's power of interpretation appears, and I think we could say that it's subject to the important limitation that it shall not contravene the established basic policy of the PRC regarding Hong Kong under Basic Law 1594. Now, Basic Law 1594 actually relates to the amendment of the Basic Law, and it says amendment of the Basic Law cannot depart from the basic principles set out in the Basic Law and also reflected in the Sino-British Joint Declaration signed in 1984. Now, given that the power of interpretation is in principle narrower than the power of amendment, it is unlikely that the MPCSC power of interpretation could exceed those restrictions expressly applicable to amendments of the Basic Law. So it could not exceed, it could not go beyond the basic principle set out in the Basic Law and also in the Sino-British Joint Declaration, which include protection of rights and freedom. And in the terms of the Basic Law and the Sino-British Joint Declaration, it's regarding the rights and freedom as one of the basic policies of China towards Hong Kong. So in our view, it's very unlikely, and we don't think that scenario would happen, in which case, as the member who raised that question was wondering whether any such interpretation might affect the basic rights and freedom enjoyed by the citizens of Hong Kong. And I would say that according to the explanation that has been given, according to the principle that any interpretation cannot go beyond the basic principle of the CPG towards Hong Kong. So it's unlikely that it would ever infringe the basic protection given to the people of Hong Kong. So that's our view in relation to the question posed on interpretation. There was another question which relates to the application of laws to Hong Kong, and this is a sort of one country, two system. What kind of laws can be applied to Hong Kong? For example, in relation to a particular matter which may be within the responsibility of the CPG, whether it can apply a national law to Hong Kong. And the answer is also in the Basic Law. Article 18 of the Basic Law provides that only laws that are now included in Annex 3 of the Basic Law of Hong Kong are applicable to Hong Kong. So national law, which have to be extended to Hong Kong, are all put under that special annex of the Basic Law. And I can give you an example of that. One of the examples is the nationality law of China, and that's, you can understand, it's something that should be applied to Hong Kong. So you can see that there are reasons for putting laws in national laws in Annex 3 of Hong Kong so that they could apply to Hong Kong. And one of the important features of Article 18 is that it actually ring fences the subject matters that could be included in Annex 3. I can read you a sentence in paragraph 3 of Article 18 on the laws that may be, on the national laws, I mean, that could be included in Annex 3 and then applied to Hong Kong. That last sentence of paragraph 3 of Article 18 reads, law listed in Annex 3 to this law shall be confined to those relating to defense and foreign affairs, as well as other matters outside the limits of the autonomy of the region as specified by this law. So there is a very specific scope of legislation that may be applied to Hong Kong from China. And it's now exclusively set out in Annex 3 of the Basic Law. It's very transparent. You can go to our Annex 3. You can see the list of law that have been extended to Hong Kong, and the list is not very long. So that gives you our answer to one of those questions that was raised. And the third question that I would like to address here relates to a question put to us by Madame Sinead. This is about the offense of treason, the offense of sedition. As I said earlier this morning, this is something that is subject to review when we come to a point when we have to implement Article 23 of the Basic Law, and we have not reached that point, although we have a constitutional duty. There was a further question about whether we have actually used those offences in prosecuting offenders in Hong Kong. I could give you a rough idea of the situation there, is that in the past 50 years, we have not done any prosecution in Hong Kong relating to the offences of treason and sedition. And the cases that I can remember, straight from the head, from my head, is one or two cases that might happen immediately after the Second World War. I think those were the exceptional cases, and in the last 50 years, I haven't come across. And if my memory serves me correct, there has been no prosecution under these two offences. Maybe I could also deal with another, a shorter question, and it's in relation to the application of the Refugee Convention of 1951 to Hong Kong, whether it's something for the Hong Kong SAR to consider. And I can confirm that in relation to the consideration of this convention, it has always been left to the Hong Kong government to decide whether Hong Kong should accede or should rectify the Refugee Convention, although, of course, only a state could accede to that convention. If we ever decided to do that, it would be through the Central People Government that we come to that. But because that decision is left to us, and as far as I know, because I'm not responsible for that policy in the government, the policy as of now, as far as I know, is that Hong Kong would not accede to that convention. That is, I think, some of the legal issues that were mentioned, and if there are other legal issues that members would like to raise, I hope if I could answer them, I could do it here, and if I can't, then I could leave it later on, maybe for a written answer to be given to the committee in due course. Thank you very much.
If I may come to whether there is any protection for asylum seekers vis-à-vis the non-refoulement principle, and what is the progress vis-à-vis those outstanding Sri Lankan torture claimants. On that count, I would like to invite Mr. Billy Wu from Security Bureau to address the committee.
Thank you, Madam. The Solicitor General just mentioned our position on the Refugee Convention. So if I may supplement from the policy angle, the 1951 Refugee Convention and the 1967 protocols, they have actually never been applied to Hong Kong before. And a very major reason is because of the very unique situation of Hong Kong. We are indeed a city of a very small size, and we have a large and growing population. That set against the backdrop of our relative economic prosperity in the region, and also our rather liberal visa regime. it actually makes us very vulnerable to possible abuses if any international convention of this kind were to be extended to Hong Kong. And the Hong Kong administration thus always had a very firm and long-established policy of not granting asylum and not admitting individuals seeking refugee status under the convention. That said, asylum claims lodged in Hong Kong have been and are handled by the United Nations High Commissioner for Refugees, that is UNHCR, its office in Hong Kong. And we must congratulate UNHCR for doing such an excellent job in Hong Kong over the past decades. In practice, on UNHCR's advice that any illegal immigrant or an overstayer in Hong Kong has lodged a refugee claim, the Director of Immigration will now, as a matter of established practice in the past decades, withhold the removal or the deportation action against the concerned asylum seeker until the completion of the UNHCR's assessment on the refugee status determination. And similarly, the Director of Immigration would also, as a matter of established practice, withhold the removal or deportation against refugees if they have been mandated by the UNHCR. That is when they are waiting to be resettled to a third country. The Director of Immigration respects and adheres to this basic humanitarian principle in exercising his discretion under the Immigration Ordinance. The principle is that absent any compelling reasons otherwise, for example, there is any grave public security concerns, a civilized community does not expel a person to a place where that person is in real danger of being persecuted. Therefore, the Director has been consistently exercising this discretion under the Immigration Ordinance for the above established practice I have mentioned, and under which actually thousands of asylum seekers pending assessment by the UNHCR and also many mandated refugees pending resettlement elsewhere, also by UNHCR, have been tolerated being in Hong Kong, and they were not removed. But that notwithstanding, though, we do reject the notion that we have such a legal obligation on non-refoulement. Also, one more thing about asylum seekers and refugees in Hong Kong. We understand that when they are in Hong Kong and waiting for the result of the assessment or waiting to be resettled elsewhere, we don't want them to go into destitution. So we have been working with a reputable NGO in Hong Kong, provide basic humanitarian assistance to these asylum seekers and refugees in an in-kind manner to take care of their accommodation or food and other basic necessities such that they are taken care of. And that's our position on asylum seekers and refugees. Going back to the chairman's earlier question on the remaining torture claims by Sri Lankans, that is not included in the 37 rejected claims. As at the end of last year, those claims are were all being handled. They were being processed. So a decision for those claims have not yet been made. That's the position on refugees and also on the CAT claim.
If the chairman permits, we will now go to the second part, the Q, question number 14 to 27, following roughly the order raised by members. First of all, we received questions about the definition of human trafficking and the legal framework in Hong Kong tackling human trafficking, plus consideration of subscribing to Palermo Protocol. I would like to invite Mr. Billy Wu again to explain the situation to us.
Thank you. First of all, about the Palermo Protocol. We note that under the protocol, apart from enforcement against human trafficking-related crimes, it also entails a much wider range of other obligations on signatories. And I have just explained slightly earlier, Hong Kong is indeed a very small place. We have a very large and growing population, and our economy is relatively strong in the region. To supplement for the committee to understand the picture better, actually there are also a lot of people movement in and out of Hong Kong daily. For your reference, in the year 2012, there were over 48 million visitors to Hong Kong just in 1 year, and that includes on a daily basis about 100,000 visitors from the mainland China. So subscription to any obligations like those under the protocol, we must be extremely careful in making the consideration. But that notwithstanding, as I have sought to explain to the committee earlier in today's session, we have a very solid framework of legislative provisions under different laws in Hong Kong against human trafficking-related crimes. And the coverage of those provisions would certainly go wider than just protection on women or children or on prostitution only. And that's about the human trafficking point that I sought to make.
Thank you. If I may now turn to freedom of assembly and expression with particular questions about police enforcement or a few incidents during national leaders' visit to Hong Kong, and questions about video recording, how is it regulated, or the checks and balances mechanism within the force. There is also a specific question about one public demonstration activity. The question referred to the homophobia incident. On that count, I would like to invite Mr. Patrick Hodson from the Hong Kong Police to inform the committee of the police initiatives.
Thank you very much. If I can first refer members to the initial queries with regard to the final report by the Independent Police Complaints Council on complaint cases arising from a visit by a national leader in August 2011. Referring to the operational policy of the police, during political dignitaries' visits to Hong Kong, it is the absolute duty of the police to ensure their personal safety, as well as the public order and public safety of the occasions they attend, and to minimise inconvenience to members of the public. The police respect Hong Kong people's freedom of expression and assembly and endeavour to facilitate the conduct of peaceful assemblies and processions. On the implementation of security arrangements, the police have to balance various factors, including the people's rights of expression, freedom of the press, and the security requirements, and to conduct professional risk assessments with regard to the prevailing circumstances for a timely and appropriate decision. It is the operational policy of the police to endeavour to strike a balance and to adopt reasonable and appropriate management measures for the purpose of safeguarding human rights and freedoms and maintaining public order, while ensuring the personal safety of the visiting political dignitaries. In regard to the Independent Police Complaints Council final report issued on the 19th of December 2012, the final report on complaint cases arising from the policing arrangements of the visit of a national leader to Hong Kong in August 2011. It released its interim report in May 2012. The investigation reports of 9 complaint cases were endorsed. The final report summarised IPCC's monitoring and scrutiny work on the remaining 7 cases, as well as its observations and recommendations on the security measures implemented by the police. As regards the remaining 7 cases, the IPCC's scrutiny results are as follows. 5 cases were endorsed. 1 case remains sub judice, as the complainant lodged an appeal against his or her conviction, which is still pending. The last case involves 6 allegations, 4 of which were endorsed in the interim report, whilst the remaining 2 allegations were classified as unsubstantiated upon IPCC's examination of the information supplied by the police. With regard to their recommendations, the IPCC made recommendations to the police that the operations wing of the force should coordinate and scrutinise the formulation of operational orders to ensure consistency. It also recommended that the police should appropriately and reasonably set up security zones, designated press areas and designated public activity areas. Clear guidelines for such arrangements should be laid down to facilitate media coverage and peaceful demonstrations. The police will give due consideration to the IPCC's observations and recommendations as stated in the final report and draw up suitable measures for handling similar situations in the future. The IPCC noted and welcomed the police's implementation of a series of improvement measures in relation to the security arrangements of another national leader in mid-2012. Such measures included strengthening communication with the public and the media on the relevant arrangements, setting up of designated press areas and petition areas at locations closer to the venues of the events to be attended by the dignitaries, as well as taking measures to mitigate the impact of such arrangements on the public. The panel on security of the Legislative Council discussed the report on the 5th of February 2013, and the members noted the recommendations of the IPC as well as the improvement measures already adopted by the police. Turning specifically to improvement measures adopted by the police to facilitate media in relation to security arrangements of a national leader's visit to Hong Kong in mid-2012, the IPCC noted that a series of improvement measures adopted by the police to facilitate media coverage included organising briefings on media coverage arrangements for reporters beforehand, setting up of designated press areas at locations closer to the venues to be attended by the political dignitary, deploying media liaison teams to the designated press areas within the security area to render immediate assistance, as well as setting up hotlines for media inquiries. The police will continue to maintain a close partnership with the media on the basis of mutual respect and understanding, and maintain communication with them to facilitate their work. If I might now turn to questions surrounding videotaping of public order events by the Hong Kong Police Force. As was discussed yesterday, the police do not install any CCTV systems in public places on a permanent basis for the purpose of maintaining law and order. It may be necessary for the police to make video recordings, such as recording the activities and movement of the crowd participating in public processions during public order events, to facilitate internal review and assessment on policing strategies so that the management of public order events and contingency plans can be improved continuously. Under the internal guidelines of the police, the recording of public order events should not target individual participants. Nevertheless, if a breach of the peace or public order has occurred or is likely to occur, the police officer recording the event may target the behaviour of those individuals who are suspected of causing or involved in that breach. The recording in these circumstances is necessary for the collection of evidence. If the recordings contain personal data, they will be properly dealt with in accordance with the relevant legislation, including the Personal Data Privacy Ordinance. With regard to our checks and balances and destruction policies, only officers who have undergone appropriate training will be deployed for the video recording of public order events. The training includes the understanding of relevant laws and powers, the use of equipment, and the purpose and procedures of the recording. The videotapes will be retained for internal review or kept as evidence for court purposes. The police have clear and stringent guidelines and procedures to handle the material so recorded, including the safe custody, proper handling and timely destruction of these recorded materials. The guidelines govern that only designated enforcement officers can handle such recorded materials, and the videotapes shall be destroyed within 31 days from the date of recording, in line with international best practice. It is necessary to retain the videotapes for more than 31 days. An authorisation from a senior police officer at senior superintendent rank shall be obtained, and this decision shall be reviewed monthly by the authorising officer. If I might turn specifically to the issue surrounding the event on the 15th of May. Specifically, the facts were that on the 15th of May 2011, Amnesty International Hong Kong organised a public meeting at a part-time pedestrian street in Hong Kong to observe the International Day Against Homophobia and Transphobia. Amnesty International Hong Kong organised a dance performance during the event without obtaining a licence or permit under the Places of Public Entertainment Ordinance. The police officers at scene advised the organiser that failure to obtain a licence for the dance performance might constitute a breach of the Place of Public Entertainment Ordinance. Amnesty International Hong Kong then stopped the performance, and the police officers continued to facilitate the ongoing public meeting. The organiser of Idaho applied for a judicial review challenging the interpretation of the Place of Public Entertainment Ordinance and its constitutionality in restricting the constitutional rights of the protection of freedom of expression and peaceful assembly. The Court of First Instance dismissed the judicial review in July 2012. As the parties concerned may further appeal, we will not further comment on details of this case. Concludes my observations.
There are questions about child fertility, with particular regard to the progress by a child fertility review panel. I would like to report here that the Social Welfare Department of the Hong Kong SAR government implemented the pilot project on child fertility review since February 2008. The review panel of the pilot project, appointed by the Director of Social Welfare, reviewed altogether 209 death cases involving children aged below 18, including 121 cases died of natural causes and 88 non-natural causes occurring in 2006 and 2007, with a view to identifying good practices and areas for improvement in the existing service system and providing recommendations. The review panel of the pilot project published its final report in January 2011. The experience of the pilot project and the positive responses received by it confirmed the value of the child fertility review mechanism. The government thus accepted the review panel's recommendation of setting up a standing child fertility review mechanism. In May 2011, the Director of Social Welfare appointed 20 multidisciplinary professionals and parent representatives and formed the Child Fertility Review Panel. The panel commenced its work by reviewing child death cases occurring from 2008 onwards and would share its review findings with the public at an appropriate time. As to questions about corporal punishment, the government of the Hong Kong SAR firmly believe that every child has a right to justice and be protected from abuse. We hope that through different public education programs and publicity, parents will better understand their parental responsibilities, parenting skills, and the harm corporal punishment may inflict on their children. The Social Welfare Department operates the Family Life Education Resource Centre, which develops resource packages on family education for use by all departmental units and social service agencies which provide family education services, with a view to promoting family functioning, strengthening family relationship, and preventing family breakdown. The packages include information on the physical and psychological development of children, parenting skills, communication skills with children, emotion and stress management for parents, as well as the skills for dealing with children's behavioral problems. I mentioned in my previous speech that we have a strengthening families and combating violence publicity program which is done annually. So I would not bore the member with repeating this combating violence publicity program. But I would just like to mention that for the annual program in 2011 and 2012, the prevention of corporal punishment was particularly included in this annual program in strengthening families and combating violence. In preventing measures against child abuse and other forms of domestic violence, the Social Welfare Department launches the Strengthening Family and Combating Violence publicity program every year, as I just mentioned. Furthermore, the Family Life Education Resource Center of the Social Welfare Department provides a variety of multimedia resource materials to all related departmental units in social welfare and social service agencies providing family services. And in terms of crisis intervention, Social Welfare Department has set up 11 family and child protective services units across the territory. They are specialized units to provide a coordinated package of one-stop service for victims of domestic violence, their families, and the batterers. It aims to prevent occurrence of child abuse and spouse cohabitant battering incidents, help the victims and their family members overcome the trauma brought by child abuse and spouse cohabitant battering, and assist the families to restore normal functioning. In the past year, the department has been allocating additional resources to improve the manpower in these service areas. We note that Hong Kong does not have specific legislation against corporal punishment. And Hong Kong is not alone, although this is not something we would be complacent about. But we note that major countries like Australia, Singapore, Canada, and UK, there is likewise no legislation to prohibit corporate punishment by parents. But I believe that each country would have to consider the subject independently, taking account of all relevant considerations in the respective local society. There is questions about the live-in requirement for foreign domestic helpers, with particular concern that this could subject the foreign domestic helpers to being vulnerable to different forms of abuse within a home setting. On this count, may I invite Mr. Billy Wu from Security Bureau to explain the situation.
Thank you, Madam. If I may supplement on the background of the living requirements for foreign domestic helpers in Hong Kong, the living requirement forms the cornerstone of our policy of importing foreign domestic helpers. It has been the Hong Kong government's established policy that, as in many other jurisdictions in the world, priority in employment should be given to the local workforce. And on this basis, importation of workers should only be allowed where there is confirmed manpower shortage in a particular trade that cannot be filled readily by the local workers. Along this principle, foreign domestic helpers have been imported to Hong Kong since the 1970s to meet the shortfall of local living domestic workers. And for the purpose of meeting this shortfall, the current regime for importing foreign domestic helpers has been far less restrictive than that for other lower skilled workers. For example, under the we have a supplementary labor scheme which imports workers at the technician level or below into Hong Kong. To ensure priority of local workers in employment, each of the application under this supplementary labor scheme has to undergo a 4-week open recruitment exercise in Hong Kong before it would be further processed and considered by the government. So you would see that should foreign domestic helpers be allowed to live out of their employer's residence, it would be against the established labor policy, and there's a risk of dampening the employment opportunity of local domestic helpers. And indeed, some labor unionists in Hong Kong have demanded that should the live-in requirement be removed, the foreign domestic helpers should then be subject to the same restrictive importation regime as that in the supplementary labor scheme, for example, as I have just mentioned. So this live-in requirement has been made known to the foreign domestic helpers before their admission into Hong Kong, and it is specified in the standard employment contract, which is signed by both the employer and the foreign domestic helper beforehand. In regard to allegations that foreign domestic helper victims who may or may not approach relevant authorities for help out of fear, the Hong Kong SAR government does not and we will not tolerate any abuse of foreign domestic helpers. Indeed, the Immigration Department takes out prosecution against employers who for aiding and abetting FDH, that's foreign domestic helpers, to breach their conditions of stay by taking up illegal employment, that is other forms of work other than the domestic work in the flat. The police will offer appropriate assistance to victims of abusers, and convicted employers are given imprisonment sentences, fines, or punishment to community service orders. And as mentioned earlier, the government also keeps in close touch with our local consulates of the major foreign domestic helpers exporting countries, as well as other migrant worker groups and non-government organizations to in a tripartite effort to protect the interests of foreign domestic helpers and to deter any potential abuses. That's the update on FDH.
There was one particular question about a religious group in Hong Kong called Falun Gong, about whether we are treating it differently or more severely compared to other groups having regular public demonstrations. On that count, I would like to invite the Undersecretary for Constitutional and Mainland Affairs, Mr. Lau Guanghua.
On the issue of Falun Gong, Hong Kong is an open and free society which subscribed to the rule of law under the one country, two systems principle. The Hong Kong SAR government remains firmly committed to the protection of fundamental rights and freedoms, including the freedoms of thought, conscience, and assembly. The freedom and right of procession and peaceful assembly are enshrined in Article 27 of the Hong Kong Basic Law and Section 8 of the Hong Kong Bill of Rights Ordinance. All people, including Falun Gong practitioners, enjoy the freedom and rights equally. According to the police record, they have not prohibited or objected to any notifiable public meetings or public processions organized by the Falun Gong practitioners or supporters in Hong Kong. We don't have any evidence which shows that the gathering of Falun Gong was discriminated in private venue. And we don't have any record of refusing entry to Hong Kong based on the background of any religion as well.
We will now come to elections. The exclusion of persons with intellectual or psychosocial disability from voting or standing for election. On this one, I would just like to reiterate the stringent condition whereby we will deem a person as having the mental problem severe enough to debar him from standing or being voted in public elections. It should be noted that a person is not disqualified merely because he or she has an intellectual, psychosocial, or mental disability. The disqualification only applies to a person who is found by the courts as incapable by reason of mental incapacity of managing and administering his or her property and affairs as under the mental health ordinance. Furthermore, under the ordinance, it stipulates that such finding by the court has to be made only after an inquiry into the matter. The applicant is required to provide to the court with 2 medical certificates made and signed by registered medical practitioners, certifying that the mentally incapacitated person is incapable by reason of mental incapacity of managing and administering his property and affairs. Moreover, the disqualification will cease to apply if the person is found under the mental health ordinance to have become capable of managing and administering his or her property and affairs again. So on that count, it is clear that the disqualification provisions are only reasonable and proportionate to the pursuit of important legitimate aims. The disqualification provisions are, in our view, consistent with Article 25 of the ICCPR. I think my colleagues have earlier on covered, Solicitor General covers from definition of treason and sedition and prosecution cases, and the police have covered videotaping, monitoring mechanism, etc., and the incidents that occur during national leader visits to Hong Kong and the and the consequential improvement measures that the police have put in place. There are, however, a few other isolated cases referred to by a member. If I may just quickly refer to them one by one. There is a question about the Chief Executive of Hong Kong sending a personal letter to a newspaper demanding the newspaper's apology. On that count, since it is the Chief Executive personal letter, we do not find it appropriate for the administration to comment here, save for the fact that I would just quote from a statement issued by the Chief Executive himself. This is a public statement. To quote, "I have all along respected freedom of speech and freedom of the press. Nevertheless, the article contains serious allegation which accused me of having relation with Triad Society. This matter has to be taken seriously," unquote. So this is something I would leave to be sought out by the Chief Executive himself. Another question is about the delay in issuing free TV license. For background, the government of the Hong Kong SAR has been processing the recommendations submitted by the former Broadcasting Authority on the 3 applications for domestic free TV program service license, and we are committed to processing the applications expeditiously and prudently in accordance with the statutory requirements and established procedures. The outcome will be announced as soon as possible after a decision is made by the Chief Executive in Executive Council. We do not accept that there have been undue delay in the processing proceedings. Freedom of the press is one of the core values of Hong Kong, which is expressly guaranteed under our basic law and has been upheld vigorously by the government. In deciding whether to grant a domestic free TV program service license, the Chief Executive in Executive Council will have to take into account all relevant factors, including the financial soundness and commitment to invest, the managerial and technical expertise, the technical soundness and quality of the proposed services, the quality control and compliance mechanism, the variety, quantity, and quality of programs to be provided, the speed of service rolled out, and the benefit to the local broadcasting industry and the economy as a whole. Therefore, it can be seen clearly that there is a holistic consideration taking into account a range of many complicated factors. Nevertheless, we are committed to making known the outcome as soon as possible after a decision is made by the Chief Executive in the Executive Council. A separate question about the independence of the Radio Television Hong Kong. For members' background, the RTHK, we call it the Radio Television of Hong Kong, RTHK, is a government-funded broadcasting office. However, it is guaranteed, its editorial is guaranteed to be fully independent. Its editorial independence is clearly enshrined in the RTHK Charter, which also provides that the RTHK is immune from commercial and political influences. And according to the RTHK Charter, the Director of Broadcasting, as Editor-in-Chief of RTHK, is responsible for ensuring that a system of editorial control in accordance with RTHK's producers' guidelines is in place to provide accurate, impartial, and objective programs. The Director himself is also responsible for making the final editorial decision in RTHK and is personally accountable for editorial decision taken by RTHK program producers. And in his conduct of his duty, the administration or government per se did not have any role to play or will not seek any interference in the RTHK's own design or delivery of the programs. We would now come to the latter part of the questions, which cover primarily ethnic minorities. There are questions about ethnic minorities' participation in electoral election, government body, or statutory bodies. I'm afraid we do not have the figures here because we do not require applicants for civil service job in government department, or we do not require candidates appointed to advisory bodies to declare their nationality. So we do not have figures as to how many or the percentage of ethnic minorities featuring in government body or statutory advisory bodies. Nevertheless, with regard to ethnic minorities' participation in the civil service, if they want to join the Civil Service Bureau of the Hong Kong SAR have public policy in ensuring open and fair competition for candidates of irrespective of their background. Appointments to the civil service are based on open and fair competition. All candidates in an open recruitment exercise, irrespective of their race, are assessed consistently on the basis of the merits and have regard to the stipulated entry requirements, including a suitable level of language proficiency to satisfactorily perform the duties required. The race of a candidate is not a relevant consideration in the recruitment selection process. Similarly, the race of serving officers is not a relevant consideration in the promotion exercise for civil service. Nevertheless, to maintain a fully biliterate, i.e. including Chinese and English, and trilingual civil service, which require Cantonese, Putonghua, and English, to ensure that we have such fluent biliterate and trilingual civil service that can operate efficiently and effectively to serve members of our public. And these are the two official languages in Hong Kong. The government needs to specify appropriate Chinese and English language proficiency requirements as part of the entry requirements for appointment to each and every civil service rank. And in setting the language proficiency requirements, the overriding principle must be to meet the actual operational needs, or a member referred to as the occupational needs of individual race, and to ensure that the language proficiency requirements adopted are relevant to and will be commensurate with the satisfactory performance of the job concerned. The latter is in line with the guidelines issued by the Equal Opportunities Commission in its Code of Practice on Employment under the Race Discrimination Ordinance. By taking into account these principles, the Civil Service Bureau of the Hong Kong Government has drawn up guidelines on the language requirement policy and promulgated such guidelines to all government bureaus and departments. We note that ethnic minorities in Hong Kong, with Chinese being a second language for most of them, have expressed difficulties in competing for civil service jobs because of the Chinese language requirement. In this regard, the Civil Service Bureau issued guidelines to heads of department or heads of grade personally, reminding them to review their language proficiency requirement regularly to ensure that the language requirements specified are only relevant and necessary or commensurate with the satisfactory performance of the duties of the grades concerned. Departments and grades have accordingly taken appropriate follow-up actions in this regard, and I would like to quote a few examples. The Hong Kong Police Force, for instance, has made suitable adjustments to the selection process for police constables, which include, among other things, consideration of candidates' proficiency in languages other than Chinese and English. In addition, the Correctional Services Department has replaced the written Chinese test, which is considered as most insurmountable by our ethnic minorities. They have replaced the written Chinese test with a group interview or an oral question session in the selection process for relevant grades. So in essence, we are encouraging the heads of department or heads of grade to consider the Chinese and English language requirement in different specific categories, both in terms of written and spoken English and in terms of written and spoken Chinese. Each of the four language requirements would have to be justified on the occupation need of a specific civil service job involved. And we will keep on the impetus to hold our departments hand in hand to urge them and encourage them to review their language proficiency requirements with particular regard to the Chinese language requirement regularly. And we will certainly hope to publicize some good examples, as I just mentioned, and encourage the departments to critically review their occupational need of individual jobs involved. This is for ethnic minorities or language requirement for the civil service. The last part is schooling for ethnic minorities in Hong Kong. Oh, I lost the paper anyway. Okay, sorry. Schooling for ethnic minority students is a difficult subject in Hong Kong. There is always a difficulty to strike a balance between the needs of majority citizens, of majority parents and children in Hong Kong with the fact that we should look after the education needs of our ethnic minorities. However, it is also a choice of a parent to choose whether they would like to place their children in a conventional school teaching standard Chinese or other language curriculum, or putting their children in the so-called designated school. According to information provided by the Education Bureau, the so-called designated school with a large number of ethnic minority students is not a schooling system by design. It is by experience and turnout that growing year by year academically, parents of ethnic minorities are inclined to send their children to school which are experienced or have proven to be able to accommodate and teach curriculum for ethnic minority students. That being the case, the issue of whether we should design a second language curriculum for Chinese language is something involving complex considerations such as education philosophy, in addition to human rights consideration. But this notwithstanding, we note the request or proposal by our NGOs, and we fully share the need to look after the education need, the development need of our ethnic minority students. And therefore, for instance, the Chief Executive in his policy address issued in January this year has also included further measures to enhance the support for non-Chinese students, among which is to base on teaching experience and the Chinese language assessment tools tailored for non-Chinese students, and a longitudinal study to further evaluate the effectiveness of measures to support these students' learning of Chinese, with a view to setting appropriate targets for the acquisition of the Chinese language, as well as improving learning and teaching and teachers' professional development. There is also an incentive grant scheme to enhance the professional competencies of Chinese language teachers in teaching non-Chinese students, and it will be launched. The policy address also calls for stepping up our collaboration with ethnic minority communities and non-government organizations to encourage non-Chinese parents to participate in diversified Chinese activities together with their children, with a view to enhancing their exposure to and the use of Chinese. We will specifically refine the summer bridging program for non-Chinese students progressing to primary 1 to 4 to allow the parents to accompany their children in the program, in anticipation that the non-Chinese students will be better supported in learning Chinese and enhancing their Chinese proficiency through parent-school cooperation. But I would just like to end by a remark that we note and agree there are much more to be done in terms of education for ethnic minorities, and we will work with our NGOs and the ethnic minority community closely in that regard. With that remark, I would close our team's reply to the questions.
Thank you, Madam Chang, for that very comprehensive response to quite a long list of questions from colleagues. Do colleagues have any follow-up questions to make, supplementary questions to clarify anything that they've heard so far? There's still a couple of minutes left. Yes, Mr. Bouzid, you have the floor, sir.
شكرا سيد الرئيس.
Thank you very much, sir. In line with the basic law in Hong Kong, religious freedom is provided for under Article 34, in accordance with Article 37 also. Religious communities can found schools, so from a legislative point of view, things are quite clear-cut. I would like to know whether the religious communities have set up schools to teach religion, and I'd like to know what main religions are taught as part of religious communities who have founded schools for that purpose. Thank you.
Thank you, Mr. Bouzid. Mr. Flinterman, you have the floor.
Thank you, Mr. Chair. I would like to thank the delegation for the very clear and elaborate answers to the questions raised. I have one further question about the comprehensive legislative framework on issues relating to trafficking in persons. I would like to ask the delegation whether it could be a little bit more specific, and let me make my question very concrete. Would certain practices relating to the importation of foreign domestic workers, which would amount to contemporary forms of slavery, fall within the definition of trafficking of persons within the legislative framework? And if so, are there any instances in which prosecution has been started in order to address such practices? Thank you.
Thank you, Mr. Flinterman. Mr. Uwasawa, you have the floor.
Thank you very much. I would like to repeat what I said in the beginning of my intervention. I very much I thank the distinguished delegation very much again for the focused and relevant responses to my questions. And I take note with pleasure the statement that Madam had made at the very last with regard to the Chinese language education for ethnic minorities, that much more needs to be done, and the willingness of the government to work with the NGOs to resolve this problem. Thank you very much. Thank you very much, Madam, Mr. Chairperson.
Thank you, Mr. Wasawa. I will now pass the floor back to Madam Chang, bearing in mind that in respect to the answers to the last 3 points, if they're going to take more than a couple of minutes, it would be better to have them in writing. And then I would invite Madam Chang then to proceed to her concluding observations before I wrap up the session. So, Madam Chang, over to you.
Thank you, Chairman. On religious schools in Hong Kong, our reports have quoted examples of such religious schools in Hong Kong. The various religions in Hong Kong embrace, among others, Buddhism, Taoism, Confucianism, Catholicism, Christianity, Islam, Hinduism, Sikhism, and Judaism. All of these religions have a considerable number of adherents. Apart from offering religious instructions, many major religious bodies have established schools and provided health, welfare, and other social services and facilities. However, when it comes to how many schools, if we wish to break down by religious body, we will need to go back and give you the information later on. On trafficking of person, I'm not sure whether I understand the question correctly, because imported foreign domestic helpers are all lawful immigrants to that extent. So why would we count them as trafficking in person and prosecute them?
Mr. Clinton, do you want to clarify? You don't need to. Yeah.
Well, thank you, Madam Mr. Chair. We have information before us about certain practices in relation to the importation of Indonesian domestic workers, where agencies charge high fees which have to be paid back by those foreign domestic workers. And coming into Hong Kong as they are, you have to give up their passports and living under conditions which could be seen as a modern form of slavery, and I was referring to that particular case. Madam Head of Delegation, my question was whether that such practices would fall within the definition of trafficking of persons. Thank you.
Thank you, Mr. Flintman. The floor is back to you, Ms. Chang.
Thank you, Chairman. We take the safeguards of the rights and contractual obligations that we offer to our foreign domestic helpers seriously. There were common, what you just mentioned, such as the employer keeping the passports of the domestic helpers, or ill-treating them, perhaps asking them to do a lot more than what is contained in the contract. We take this issue seriously. And I wouldn't want to go over the large amount of publicity, counseling, and education work that we do, both at the strata of the foreign domestic helpers, Indonesian, Filipino being the major source of imported workers on that count, and vis-a-vis the employers as well. But I can go back and give you cases, including how we are taking up such complaints by foreign domestic helpers with particular regard to Indonesians, and the legal framework, as we just mentioned, the comprehensive legal framework that we seek to tackle traveling in person. Thank you.
Thank you, Ms. Chang. And now it's back to you for your closing remarks.
Thank you, Chairman. It is indeed our pleasure to attend the Human Rights Committee's hearing on the Hong Kong SAR's third report in the light of the covenant. It gives us, and me and our team, the opportunity to review the developments made since the last hearing in 2006 until the submission of our third report in 2011. The Hong Kong SAR has made improvements in areas such as the enactment of specific legislation against race discrimination, introduction of a statutory screening and appeal mechanism to process torture claims, enactment of the Independent Police Complaint Council Ordinance, and major enhancement of legal aid services, etc. However, challenges lie ahead in building up consensus on constitutional development for attaining universal suffrage for electing the chief executive in 2017, in accordance with the Basic Law and the decision adopted by the Standing Committee of the National People's Congress of the People's Republic of China. The Hong Kong SAR government fully recognizes the importance of protecting the rights of different groups, including sexual minorities. While we will continue to listen to the views by different groups and strike a balance on this matter, we are also committed to taking forward comprehensive programs to combat discrimination on the ground of sexual orientation, including research and studies, public education and publicity initiatives, and establishing more effective forums to engage the stakeholder groups. Since the establishment of the Hong Kong SAR 16 years ago, Hong Kong does not lack controversial issues, with sectors of the community holding diverse, if not opposing views. Our experience confirms that the most effective solution in dealing with these situations is by talking to the community, encouraging their rational and informed discussion with a view to facilitating the building of community consensus. And we will certainly spare no effort and will adhere to the consultation and engagement policy in dealing with these outstanding challenges ahead. Needless to say, at the international level, we look forward to continuing the very meaningful working relationship with the Human Rights Committee, and we thank you, Chairman and members here, for giving us most invaluable comments, observations, and suggestions for our continued improvements. Thank you.
Thank you very much, Madam Chang. I'll just say a few closing remarks which should not be taken as anything other than a few personal points that strike me as salient, that I've noticed that colleagues are concerned about, but certainly without prejudice to the actual concluding observations that will be made by the committee. You've already heard how appreciative the committee has been, both for the report, the detailed responses to the list of issues, and then the very focused and detailed responses that you have given to the questions that colleagues have raised during the hearing. That wasn't just diplomatic, it was very much appreciated, the seriousness of the delegation and its approach to the committee. It's very clear that Hong Kong does indeed have a high degree of freedom, including of freedom of speech, and respect for the rule of law. These are important achievements, but they're achievements that both inside and outside countries can't always be taken for granted. They always have to be defended. And it's not unusual, perhaps, for small populations very close to large populations, especially when those large populations may not even have the same international commitments to human rights and the rule of law, for there to be nervousness abroad and I don't mean abroad, meaning internationally, about what the future may hold. And so it's no surprise that that when public order measures are taken to apply literally language relating to securing approval of public protests even when there is no real threat to public order, or even less entertainment and invoking legislation on public entertainment, not even for profit, that is not seen as a means of expression, is the sort of thing that can be troubling both probably to people in Hong Kong and certainly outside. It doesn't mean that there isn't a high degree of freedom, but it does mean that that people can't feel confident of maintaining that degree of freedom. The problems of interpreting the basic law, we've been told how rare it is, but it does come very strange to have a law that would be interpreted not only not within the community that is bound by the covenant, but not even by a court, but by the very body that adopted the basic law, which does raise issues of separation of powers and indeed issues of rule of law. And of course we are reassured that about the rare use of it by the government, but also note that the courts may themselves decide to take that measure, and sometimes seemingly on the basis of issues that didn't sound as important as fundamental issues affecting the whole China scene. The issue of possible returns of people who come to China is an important one. We've been reassured, I've been reassured at any rate, by the seriousness with which we're told the authorities approach the question of non-refoulement. Slightly troubling to hear that the idea is one that is rejected in principle. Understandably, the state party would not feel itself bound by the Refugee Convention, but the term non-refoulement extends beyond that, and it's very clear that it would be a violation of the covenant to expose somebody to a violation in some other place, and especially a serious violation such as the prohibition of torture or cruel, inhuman or degrading treatment or punishment. And I do hope that the state party isn't rejecting that notion of non-refoulement. On the issue of corporal punishment, which some colleagues have been concerned about, some examples were given of other countries where there isn't a law, but most countries do have laws relating to assault, and certainly the UK, you mentioned the UK, my own country has been found in violation by the European Court of Human Rights in respect of serious infliction of physical pain and suffering by parents, and tolerated by the legal system, which of course is then having to be repaired in that sense. So it's a question of the physical integrity of children, and children have that physical integrity under the covenant, and especially under Article 24. It's not just an issue of Article 7. So those are the questions. Those are the issues that seem to have drawn colleagues' attention. I've left till the last the issue of universal suffrage. Obviously, that is one that continues to be a problem, regardless of the interpretation of the application of whether the reservation even applies since the change of administration of Hong Kong. The it's obviously undesirable, and it's recognised by all parties to be undesirable, since the ultimate aim is indeed to achieve universal suffrage. I found it reassuring that, as I've understood, there is a commitment now to universal suffrage for the Chief Executive in 2017 and universal suffrage for the Legislative Council in 2020. That does suggest that we'll be close to it by the time we next meet each other. It would have been good if it could have been an achievement by the time we next meet each other, but certainly on the right track. So with that, many thanks to you for the splendid cooperation. It has been indeed a very constructive dialogue. I thank the interpreters once again for the indulgence of another 5 minutes of their lunchtime. Meanwhile, have to inform the delegation that there is now 48 hours for submission of any further information in writing that the delegation may wish to submit for the purposes of being taken into consideration for the concluding observations. I should announce that at 3 o'clock we meet in closed session. At 3 o'clock there is a bureau meeting, which of course is in closed session, and then at 4 o'clock we're back in public session, first for methods of work for 1 hour, and then for meetings with NGOs and national human rights institutions for the final hour. So with renewed thanks to the delegation and wishing them a safe return home, I now suspend the session and wish everybody a nice lunch.